Hello everybody, I am Dr. Rangeen Tripathi from National Law University, Odisha, and I welcome you all to this course on substantive criminal law. I hope you have been enjoying the other modules which has been taught to you so far, and I hope that you will be able to enjoy this module as well. Today, I'll be speaking to you on the topic of offences relating to marriage. The basic objective of this particular module is to make you aware about the circumstances in which any conduct in relation to marriage is criminalized, and to also make you aware about the nuances and ingredients of the different offences in relation to marriage, such as bigamy, adultery, criminal elopement, and so on. Before we begin our discussion on offences relating to marriage, we must first understand that marriage is a union between two individuals, which is primarily a personal legal relationship. It is something which concerns the private affairs of the person, and therefore generally the aspects of marriage are governed by the personal laws which are applicable to the different individuals. For example, Hindus are governed by the Hindu personal law, Muslims are governed by the Muslim personal law, Christians are governed by the Christian personal law. Now, in this context, the question arises as to why criminal law should be concerned about a personal relationship between two individuals. It is in this context that we need to remember that marriage is also a social institution. It is the foundation of the primary unit of the society, that is a family. It is for this reason that the state and the law is deeply concerned about how marriages are sustained in a particular society. Criminal law concerns such conduct which, though may be directed at individuals, is harmful towards the general interest of the society. It is here that criminal law finds an interface with personal law, and various aspects in relation to marriage form not only a part of the personal law of the land but also the criminal law of the nation. Now, we need to understand what is meant by offences relating to marriage. Now, let's say a married man is cheated. Is that an offence related to marriage? A married woman is assaulted on the street. Is that an offence related to marriage? The answer is no. Because any offence which pertains to a married man or a woman does not become an offence related to marriage. Offence relating to marriage refers to such offences which strike at the core of the social institution of marriage, which violate some of the fundamental tenets of the concept of marriage. And we will be discussing such offences only. Now, Chapter 20 of the Indian Penal Code lists the different offences in relation to marriage, and the chapter is also titled as Offences Relating to Marriage. But we need to remember that that is not the only chapter in which the different offences in relation to marriage are listed. There are certain other sections, for example, Section 304B of the Indian Penal Code, Section 498A of the Indian Penal Code, and certain clauses in Section 375 and 376, which also deal with offences which can be conceptually classified as offences relating to marriage. As there are other modules dedicated to dowry law in relation to Section 304B and mental cruelty under the domain of domestic violence under Section 498A. We will be discussing the other offences which have been listed in Part 20 of the Indian Penal Code and the two other offences which have been mentioned in Section 375 and 376A of the Indian Penal Code. The first such offence which we will be discussing, cohabitation caused by impersonation. Impersonation refers to one man assuming the identity of another. This particular offence is covered under Section 493 of the Indian Penal Code. The essential ingredients of this offence are as follows. A particular woman is not married to a particular man. Let's say X and Y are not married to each other. Here X is a woman and Y is a man. And the man, by deceit, causes the woman to believe that she is lawfully married to him. That is, Y causes X to believe that X is married to Y. Then the man causes her to cohabit or have sexual intercourse with him in that belief. That is, Y by deception causes X to believe that X is married to Y, and under that belief either cohabits with her or has sexual intercourse with her. When Y commits such an offense, he can be punished with imprisonment of either description, that is either simple imprisonment or rigorous imprisonment for a term not extending 10 years, and he is also liable to fine. For this offense, the core ingredient is deception. It must be shown that Y has deceived X. It must be shown that Y has done something to cause that particular deception. And because of that deception, X was led to believe that she is lawfully married to Y. If X was aware that Y is not her husband, and nevertheless she has sexual intercourse with him or cohabits with him, then there is no offense which has been committed by Y. If Y has done certain things in order to deceive X, but that deception has not worked on X, that is, she has not been actually misled to believe that Y is her husband, then also Y will not have committed any offense. The next offense which we'll be discussing is the offense of fraudulently going through an unlawful marriage. Now we need to understand that a marriage is a legal relationship between two individuals. When two individuals get married, they acquire certain rights in relation to each other, they incur certain duties in relation to each other, and that creates also a legal relationship vis-a-vis the couple and the rest of the world. So when a person undergoes the ceremony of a marriage, fully knowing that no legal relationship is going to result therefrom, then the person is causing fraud on the other person. It is this offense which is covered under section 496 of the Indian Penal Code. In order to satisfy the requirements of this offense, 3 ingredients must be fulfilled. First, a man must have gone through the ceremony of being married with a woman. That is, H has gone through the ceremony of being married with W. H must have gone through this ceremony with the knowledge that he is thereby not lawfully married, for whatever reason it may be, either because he has an existing wife or because of some other reason. He knows that by undergoing that particular ceremony, he is not getting married to Y, and he must have done so with a dishonest or fraudulent intention. If H has done all these 3 things, that is, he has gotten married to Y under a ceremony, he has gotten married to Y knowing that by undergoing that ceremony there is no lawful marriage which is taking place, and he did so with a dishonest or fraudulent intention, then he has committed an offense under section 496. If he has done so, he can be punished with imprisonment of either description for a term which may extend to 7 years, and he is also liable to pay fine. It must be noted here that at the time of entering into marriage with W, H must have had a dishonest intention as defined under section 24 of the Indian Penal Code, or he must have had a fraudulent intention as defined under section 25 of the Indian Penal Code, and that intention must have been present at the time of entering into the ceremony of marriage. If H has developed some dishonest or fraudulent intention subsequent to the act of the ceremony, but not at the time of it, then no offense has been committed by him. What is relevant here is the time at which he had a dishonest and fraudulent intention, which is at the time of getting married to W, and not at a subsequent time.